Did the Justice Department just make it easier to discriminate as long as you don't admit it? Because on December 9th, 2025, the DOJ finalized a Title XI rule that wipes out something called disparate impact, one of the main tools that the federal government has used for decades to prove racial discrimination using data, not just ugly emails or slurs. In this video, I'm going to break down what it means that the DOJ has eliminated impact liability under Title XI, why supporters call it restoring meritocracy, why critics see it as the end of a systemic discrimination enforcement, and what it means for your policies on the actual ground. So first off, what did DOJ actually do? On December 9th, 2025, the Justice Department announced a final rule changing its Title XI regulations. That's the part, by the way, of the federal law that says if you take federal funds, you can't discriminate based on race, color, or national origin. Before this rule, DOJ's regulations covered intentional discrimination and policies that were neutral on their face but had a disparate impact on protected groups. The new rule basically says we're deleting the disparate impact provisions. From now on, we only enforce Title XI when we can show intentional discrimination. All of the have the effect of language is gone. The affirmative action language built around fixing disparate impacts, also gone. But why now? Well, the rule is a DOJ carrying out Executive Order 14281 called Restoring Equality of Opportunity and Meritocracy. That order told federal agencies, find your regulations that allow disparate impact liability under Title XI and eliminate them. The federal policy is to move away from disparate impact liability wherever possible. DOJ also leans on the Supreme Court case like Alexander v. Sandoval and the 2024 Loper-Bright. These decisions will argue that Title XI itself focuses on intentional discrimination and that earlier disparate impact regulations stretched their authority. That's the legal story they're telling. But the next big question is, what is disparate impact and why does it actually matter? Let me give you a quick example. Imagine a city says, we're going to pick up trash faster in neighborhoods where residents file more online complaints. Nobody mentions race. This policy is neutral on paper. But if wealthier, mostly white neighborhoods have better internet access and know how to use the complaint system, they get cleaner streets and faster service, while low-income, mostly Black or Latino neighborhoods live with overflowing garbage. Under a disparate impact standard, civil rights lawyers can say, look at the outcomes. This neutral policy is disproportionately harming people of color. That can be a Title VI problem, even if no one admits bad intent. Under the new DOJ rule, that's no longer enough. To make it a Title VI case, you now have to show that the city meant to treat those neighborhoods worse. And in real life, almost no one sends an email that says, hey guys, let's design this to hurt a particular racial group. Disparate impact tools were built to catch the effects of policies when you don't have that kind of smoking gun, or maybe even that smoking gun isn't there. So the question is, how are people reacting? And as you might imagine, it's mixed. Supporters of the rule say disparate impact liability forces race-conscious decision-making and pushes agencies towards quotes or soft quotas. It punishes neutral merit-based policies just because the numbers don't come out evenly. Congress never clearly authorized disparate impact rules under Title XI, so this is a legal course correction. That's why you see phrases like restoring equal protection and meritocracy in the official messaging. However, critics say this doesn't restore equal protection. It removes a core civil rights tool. Racial disparities in policing, housing, education, and environmental enforcement usually show up in patterns and data, not in open admissions of bias. Without disparate impact, communities are told their outcomes don't matter legally unless they can prove that it was in someone's head to do them harm. More than 200 former DOJ Civil Rights Division staff have publicly warned that this is a part of a broader weakening of civil rights enforcement. Same rule, very different narratives. So the next big question for you guys to ask is, what does this actually mean in practice? Well, let's go sector by sector briefly. For universities and colleges, DOJ is effectively saying, we won't treat alleged systemic racism or sexism in your policies as a Title XI violation without proof of intent. So things like admissions criteria that produces big racial gaps, campus policing or discipline that falls hardest on one group, financial aid rules that leave certain communities behind, those can still be treated as controversial. And you can still face lawsuits under other theories. But DOJ's Title XI enforcement toolbox is now narrower. You can't rely on disparate impact theories alone to get DOJ involved. You now need someone to sign that it was intended for unequal outcomes to occur. For state and local governments, if you run a department that takes federal money, think transportation, housing, police, health, schools, your Title XI risk used to include route changes that isolate certain neighborhoods, zoning or permitting that repeatedly burdens the same communities, policing and ticketing patterns that show big unexplained racial disparities. Those were not just PR headaches. They could trigger a Title XI investigation based on disparate impact. Now DOJ is saying we're not bringing Title XI cases based solely on those disparities. You still have political risk, by the way, reputational risk, and possibly risk under other laws, but the specific DOJ disparate impact hammer has been put down. In terms of environmental justice, you can see this shift already. Take an example like illegal dumping concentrated in Black and Latino neighborhoods. Under the old approach, Title XI disparate impact tools let DOJ treat that as a civil rights issue, even without direct proof of racist intent. Under this new rule, DOJ is signaling that without proof of intent, it's not a Title XI case. So environmental justice advocates lose one of their main federal levelers using Title XI disparate impact theory to challenge where pollution, landfills, or toxic sites are concentrated. For contractors or grantees, if you're a private contractor, nonprofit, or business that receives federal funds in areas like transportation and infrastructure, health and human services, education, or criminal justice and reentry, your formal exposure under DOJ's Title XI disparate impact framework is lower. But you are still bound by Title XI itself. No intentional discrimination. Other agencies might keep their own disparate impact rules longer, and public scrutiny doesn't care which subsection of the DOJ edit impacts you. If your hiring, leading, enforcement, or service delivery produces stark racial disparities, you may dodge a specific DOJ disparate impact investigation, but you are not dodging headlines, advocacy campaigns, or legislative interests. And then just one more piece. How did DOJ move this quickly? Well, this rule came out without the typical notice and comment process people expect for big regulatory changes. DOJ's position is we're just aligning our regulations with the statute and Supreme Court decisions, so a full process isn't needed. However, critics are responding with, this is a major shift in a 50-year-old civil rights framework, exactly the kind of change that deserves maximum public input. That fight over process is likely to show up in court challenges. So where does this actually leave us? The simplest way to think about this is for decades, the federal government used both intent and impact to spot discrimination under Title XI. DOJ has now narrowed its own role to intent only. Other agencies and laws may keep pieces of disparate impact theory alive, and future administrations might try to rebuild it. But for now, a key enforcement channel has been downgraded. And it raises a basic question. Is discrimination something we measure only by what people say they mean, or also by what their policies actually do in the real world? For now, at least at the DOJ under Title XI, the official answer is we're only looking at what you meant to do. How you respond to that in your organization and your policies is a part that you still control. If this helps you understand a little bit about what's happening at the Department of Justice and what's happening with disparate impact, please make sure to subscribe, hit that like button. If you got any questions, feel free to comment below, and we try to answer everything as it comes in. Thanks for watching.